Gerald Newman. I'm one of the directors of the Human Rights Program here at the law school. And it's my great privilege to introduce to you Dr. Agnès Callamard, who is the Special Rapporteur on extrajudicial summary or arbitrary executions. That is one of the thematic mandates, one of the special procedures under the auspices of the Human Rights Council of the United Nations, tasked with overseeing and explicating particular human rights on a global basis in relation to all the states of the world. And she's going to talk to us today about one particular aspect of the work in relation to a gender-sensitive approach to arbitrary killings. Please join me in welcoming Dr. Callamard.
Good afternoon, everybody, and thank you for coming to my talk. I know the pizza had a lot to do with it, but hopefully you're also interested in my presentation and the work I do. So I have been appointed as Special Rapporteur on arbitrary killings a little bit more than a year ago, and I have produced already 2 reports, the first one being a gender-sensitive approach to arbitrary killings, which is the one I have been asked to introduce to you today. Before I do that, I wanted to explain a little bit why I selected that topic for my first report. I'm coming from 20-25 years of work on human rights, and during that period I have more or less consistently elected to understand human rights first and foremost from the standpoint of the experience of people, the experience of victims. And it has been clear to me that experience of human rights, fulfillment, enjoyment, exercise of human rights is a heavily gendered process. However, that gendered analysis had not been applied so much to extrajudicial summary arbitrary killings, a very old mandate, some more than 20 years, and a mandate that for very logical reasons has focused largely on the relationship between security forces and individuals, mostly men, and a relationship taking place in the public sphere. For those reasons, other individuals' experiences of death and life, including women, had not been considered through the lenses of my mandate. And it felt to me that it may be doing a disservice both to the human rights framework and to potential victims not to be able to apply that particular normative category to the experience of death of those victims. So that first report focused on a gender-sensitive approach and on gender-based killings. I've understood gender not, of course, as the equivalent of woman, but as being a far more open category, one that is linked to people's experience of their sex, but also of how they interact with others in their body, how they represent their gender identity through the way they dress, through the way they speak, and so on and so forth. So my report attempts to address gender-based killings, and I have somehow narrowed that down to look mostly at women and at LGBT. This is not to say that you cannot apply a gendered analysis to the killings of men or to the killing of straight people at all. You actually can and you ought to. But for the purpose of my report, I have focused mostly on women and LGBT. I have also determined fairly early on in my thinking that gender never stand alone as a determining factor in people's life, including in their gendered identity, and that there are other identifiers that play a very important role that must be integrated into our analysis if we want to have a fuller comprehension of their experience of death and of the normative framework of arbitrary killings. That meant that I looked as well as gender in its relationship with race, ethnicity, religion, and indigenous people or disability. As far as the mandate is concerned of extrajudicial summary arbitrary killings, it's unlike a number of other special rapporteurs. I do not have a right to defend. However, the mandate is related to the right to life, which is Article 6 of the ICCPR. The notion of extrajudicial summary or arbitrary killing have been the object of a great deal of normative development, standard setting. But as I have mentioned earlier, most of them have been characterized as falling within the public domain, that is the domain of the state and its institutions, and have mostly been meant to encompass killings involving state officials or private actors connected to the state. However, a large number of victims of violent death are actually experiencing those violent deaths in the private sphere. And the question I've asked myself is, to what extent are those violent deaths something that should be of concern to my mandate and something that could be characterized as an arbitrary deprivation of life or an arbitrary killings? I wanted to look at that particularly because I think that we need to be very careful. We have a responsibility as human rights thinkers not to suggest a hierarchy in the way we approach certain experience, and not to suggest that some death may be less important than others because of the normative categories that we apply. This does not mean that every normative categories can apply to everything, but I think we just need to have a cognitive process whereby we really think of the power that we communicate when we define a certain violation according to certain term. So for those reasons, I have done 2 or 3 things that I want to propose to you with regard to my approach. Just give me 1 minute because there is something with the, thank you. All right, so what did I do in order to apply, to determine whether or not these violent deaths amount to an arbitrary deprivation of life or an arbitrary killings? To do so, I've looked first at the nature of those deaths, and in the report you will find a number of examples which are meant to give more authenticity to what I am trying to do. So of course, for women, it's going to be domestic violence, for instance. For a number of transgender people, it's going to be violent death in the context of their community. For women or girls with disability, it can be death at the end of their parents and infanticide, and so on and so forth. So those examples give me the empirical data I need in order to then determine whether or not these are arbitrary deprivation of life. First step. Second step is to understand these labels that are part of my mandate: arbitrary, deprivation of life, or killings. So the notion of arbitrary is a very important one in international human rights law. It's one category that we find in a number of mandates and in respect to a large number of human rights. However, there is no standardized interpretation of the meaning of arbitrary, which is not necessarily a bad thing, by the way. For my purpose, I've looked at a variety of normative sources, including particularly the Human Rights Committee and its jurisprudence, not just a general comment. But ultimately, I felt that there were two sources that were very helpful. One was from the African Commission, which last year produced a general comment on the right to life, which I will invite you to consult if you have not done so, and where it defined arbitrariness as follows, with reference to considerations such as appropriatedness, justice, predictability, necessity, and proportionality, which is pretty straightforward. But it also adds that any deprivation of life resulting from a violation of the procedural or substantive safeguard of the African Charter, including on the basis of discriminatory grounds or practices, is arbitrary. So there, they introduce a term that I had not seen articulated so far, which is discrimination. And it's an important term for me because empirically speaking and normatively, when my mandate, including myself as the last holder of it, when we look at arbitrariness in the context of death penalty in particular, in order to determine whether a death sentence is arbitrary, we looked at the biases in the process, both procedurally and substantively. And one very important part of it will be whether or not there is any evidence or at least allegations that the process has been biased because of the defendant's race, ethnicity, religion, or indeed gender, which is less likely, although it does happen. So all of those led me to propose a definition of arbitrariness that placed a great deal of emphasis on the notion that anything that is procedurally or substantively grounded on discrimination in law or practice could constitute could amount to arbitrariness, particularly when applied to the right to life. That's the first thing. The second element in arbitrariness that is really important is that every committee, human rights bodies, and normative sources agree that you do not need deliberate intention on the part of the state to conclude that something is arbitrary. And I think it's a very important part of it. So, of course, it's stronger. Arbitrariness is stronger when you can link it to a deliberate intent on the part of the state to do something in a discriminatory fashion, for instance. However, a killing can be arbitrary even though the killer may not have intended to kill. And that's very clear in situation of excessive use of force or lethal force. In fact, in most situations, or in a number of situations, shall I say, the security official that has killed may not have intended to kill. But because of the disproportionate use of force or the unnecessary use of force, we are bound to conclude that the killing was arbitrary, even though it was not intentional. So that's important. Now, that was one element that I needed to unpack from the standpoint of gender. The second element was how do we bring non-state actors into the arbitrary deprivation of life. And there it was actually very easy because I just had to rely on 20 years or so of normative development. Almost, for the last 20 years, international human rights body, regional ones and domestic ones have agreed that the safeguard against arbitrary deprivation of life applies to killings by non-state actors, and that there is nothing in the wording of Article 6 that limits the prohibition of deprivation of life to act of commission by the state. in one particular important jurisprudence from the Inter-American Court has argued the case very well, saying that state inaction or omission may result in an arbitrary deprivation of life and a violation of the right to life. So under which circumstances can those killings by non-state actors be deemed arbitrary and amounting to a violation of Article 6? There we need to look at a concept that has been very much in place for the last 20 years, which is the concept of due diligence and the failure of the state to exercise due diligence, which is to act to prevent, investigate, punish, and provide compensation for human rights violations, whether committed by state or non-state actors. So that standard applies both to the negative and positive obligation of the state and is found in numerous international instruments. It has been particularly well developed in the context of violence against women and gender-based killings, and in fact, there is almost too much written on due diligence, because when I looked back at it, having worked on that 20 years ago and then looked back at it again now, I somehow felt that we may have missed the essential nature of the concept of due diligence through a very heavily technical development of it. But anyway, that's my feeling. What does the due diligence standard tell us? It, as applied to prevention, it says that basically there is a test, in my view, that can be used to determine whether the state failed to act with due diligence to prevent killing, particularly by non-state actors. A, how much the state knew or should have known of the risk or likelihood of harm and the seriousness of this harm. So how much it knew, the risk, and the seriousness of the harm. These three-part test is very important when you apply them to gender-based killings, either women or killings in the community. That didn't raise too many questions, actually. There is a great deal of jurisprudence on that test throughout the world, Inter-American, European, and other development. What was more complex for me when I was developing that report was the idea that the positive obligation of the state meant, in essence, progressive implementation. And I was really struggling with trying to bring back together the notion of the right to life, which is which has a very high burden on the state, and the notion of progressive implementation. And so what I attempted to do in my report was to suggest that when you apply the notion of progressive implementation to the right to life, you need to be extremely careful not to suggest that it could take a very long time for that implementation to take place. And we should be very careful not to suggest that it imposes only obligation of effort and not obligation of result. For instance, the obligation of investigation into human rights violations, when applied to the right to life, is non-derogable. In fact, it's non-derogable for every violation. But in the context of the right to life, if a government fail to investigate, that in and by itself amount to a violation of the right to life. I cannot see how you could impose a progressive implementation on that particular obligation. So that's the first thing. The obligation of prevention, sanction, and so on, in my view, also imposes equally firm obligations on the state when it comes to preventing violations of the right to life. In fact, One of the jurisprudence which I cite in the report is Opus versus Turkey. And the European Court here determined that when authorities are aware of instances of grave domestic violence, it falls upon them to undertake effective action of their own motion. The court judgment implies that in order to fulfill, in that case, the European Convention obligations, governments must aggressively, I will say, pursue criminal proceedings in cases of alleged domestic violence. Such proceedings must be effective in order for the obligation of prevention to be met. Again, you can't quite apply the notion of progressive implementation and effort as opposed to result to that obligations when applied to the right to the prevention of arbitrary killings. A similar logic can be found in the Inter-American jurisprudence, which has concluded that it is not the formal existence of remedies that demonstrate due diligence, but rather that they are available and effective. And to me, availability and effectiveness are two fairly high standards which cannot be tallied with a very long-term progressive implementation. All of these have led me to conclude that when applied to the right to life and to arbitrary killings, the obligation to respect and protect is a non-derogable obligation of immediate effect. And to the extent, for instance, that women are the victim of unlawful death in the private sphere, or that, let's say, transgender people are the victims of violent death in the community, there is an immediate obligation placed upon the state to protect, including through prevention, investigation, sanction, and reparation. So the fact that these are positive does not imply weaker obligations, and effort-based obligations do necessitate demonstration of effectiveness, non-discrimination in the allocation of effort, and very importantly, firm legal protection. So this was very important for me because there is so much, in my view, meddling and muddying of the notion of progressive implementation, which I felt were pretty dangerous when applied to the prevention and the protection against arbitrary deprivation of life. So altogether, I concluded, I think one of the key findings is that not all unlawful death of women or of LGBT people, meaning gender-based killing, not all of them amounts to an arbitrary deprivation of life. To demonstrate that there has been an arbitrary deprivation of life, you also need to link that killing to some notion of discrimination in the way the state has failed to prevent, respond, investigate. You also need to demonstrate that the state knew or should have known of the likelihood or the risk experienced by the victim and of the seriousness of the harm, in this case, death. So the threshold is pretty high, but it is not an impossible threshold to meet. And in fact, it applies to a large number, in my view, a large number of unlawful deaths, both in terms of identifying individual responsibilities, but also the systemic context that have resulted into those killings. If the time allows, I just want to make, do I have the time? Just want to add one more element of a gender-sensitive approach to arbitrary killings and arbitrary deprivation of life. A large number of deaths around the world, in fact, the vast majority, take place in situation of extreme poverty or in situation of extreme discrimination. Historically, as you probably know, there has been a very marked distinction drawn between civil and political right and economic, social, and cultural right. My mandate and my article, Article 6, is linked to the civil and to the ICCPR. As a result, the right to life has rarely been analyzed in the context of non-realization of economic, social, and cultural right. It has been mostly interpreted as a negative right, as I have pointed out earlier, as a right not to be deprived of life as a result of state action, even though I have just shown that there is ample normative development linking that to state inaction and omission. So if we want to analyze the right to life, as I do, through the lived and death experience of people, I need to take into account, in my view, the fact that a large number of death and a large number of people around the world experience life and death through their economic and social situations. Poverty is also a gendered experience. It's very clear with the situation of women. It's also clear with the situation of women with disability, with indigenous women, with black women in many parts of the world. It's also clear with the situation of trans people, which are often, because of discrimination in society, forced into very risky occupation, including prostitution or sexual work. So for taking this into account, I ask myself, under which conditions can such death, let's say as a result of non-access to basic services such as maternal services, under which condition can such death be analyzed as an arbitrary deprivation of life and possibly an arbitrary killing? And in my report, I go back to the jurisprudence on ESCR when it has tried to approach it from a right to life standpoint. And I found that there are three possible approach to the interaction between Article 6 and ESCR. The first is the one I have already talked to you about, which is a due diligence test applied to situations in the social economic in a social economic context. And here, one of the key jurisprudence is Soma Yaksa. I'm sorry, I can't pronounce the name very well, where the Inter-American Court found that the failure by the state to provide access to healthcare facilities and the death that ensued resulted in a violation of the right to life. A second approach is through a focus just on discrimination. And the Committee on the Elimination of Discrimination Against Women, in its landmark decision of 2011, Da Silva Pimentel versus Brazil, recognized that states have an immediate and enforceable human rights obligation to address and reduce maternal mortality, and it stressed that limited access to quality maternal health care that fail to address the specific needs of women constitute discrimination, and therefore that the right to life is violated whenever women die as a result of being denied access to quality health care, because the lack of appropriate maternal services has a differential impact on the right of women. So here, to me, of course, due diligence remain an important element, but the court there really insisted more on the discrimination angle and what differentiates men and women in terms of access to certain services. And then there is a third approach, which has been advocated in part by the Committee on Economic and Social Rights, which is the notion of minimum core obligation and priority obligations. And in its general comment 3, the committee suggested that a minimum core obligation to ensure the satisfaction of, at the very least, minimum essential levels of each of the rights is incumbent upon every state party. In subsequent general comment, the committee has also suggested that the so-called progressive realization imposes an obligation on the state to move as expeditiously and effectively as possible towards full realization of the rights. So there is ample evidence that discrimination enforced by law, custom, or practice, and that in many circumstances, women's right to life will be violated as a result of a violation of their socio-economic rights itself grounded in or resulting from systemic discrimination against women and girls intersecting with their social economic status and other identifiers. I don't think I need to get into the evidence of that, but there is plenty of it around the world. Suffice to say that, for instance, as far as women are concerned, a large number of deaths in maternal mortality is one of the very big killers of women around the world, and particularly of poor women. Moving away maybe from a gendered analysis, my colleagues who have a social economic rights mandate, for instance, who are working on the right to housing, have made very strong analysis, in my view, of how homelessness and more generally the lack of adequate housing is certainly violating the right to life, and that death resulting from homelessness should be seen under certain conditions as amounting to an arbitrary deprivation of life. So what all of this suggests is that some violations of the right to life stemming from the non-fulfillment of economic and social rights may constitute an arbitrary deprivation of life. And as various courts have suggested, and as I am also suggesting, the level of mens rea required to demonstrate states' violation of the right to life is not only criminal intent, which of course is still important for some killings, but also negligence through act of omission or commission. The state knew or should have known, failed to take action that could have prevented those deaths, and in many circumstances, that failure is grounded on discriminatory law, discriminatory practices that may be gendered, that may be based on social economic status. I've elected in my report to pick one of the most controversial case study I could ever pick, which is abortion. A large number of women, I don't think I have the number here, die because of lack of access to safe abortion and because they resort to unsafe abortion. Treaty bodies and special procedures, mandate holders have consistently condemned countries that criminalize and restrict access to abortion, making direct links between the criminalization of abortion, maternal mortality, and the right to life. Noting that such laws violate the right to life of women, the Human Rights Committee and the Committee Against Torture, for example, have expressed concern about restrictive abortion laws, including absolute ban on abortion, as violating the right to life and prohibition of torture. I go a little bit further than that. I'm suggesting in my report that states right now have extensive knowledge of the life-threatening implication of unsafe abortion and of the consequential number of deaths resulting from women turning to unsafe abortion. There is not one state actor who should not know that, because the evidence is for everyone to see, and international bodies such as the WHO or UNFPA have all this evidence, including at domestic level. Yet, some states choose to impose an absolute ban on abortion and to criminalize it. In my view, based on all the precedents I highlight in my report, I conclude that if a woman was to die, and that this death can be medically linked to a deliberate denial of access to life-saving medical care, in that case, safe abortion, because of an absolute legal ban on abortion, which can only affect women or girls, this, in my view, would amount to a gender-based arbitrary killing only suffered by women as a result of discrimination enshrined in law and lack of due diligence on the part of the state. I'm further alleging or suggesting that in situations where the ban is not absolute, but where women nevertheless die because of access to unsafe abortion, we ought to be able to conclude that these deaths amount to an arbitrary deprivation of life, as opposed to an arbitrary killing. So in conclusion, that report, that first report, and my analysis try to do a couple of things. The first one is to look at my mandate from the standpoint of a number of victims and of deaths that had not been considered so far as falling within the remit of my mandate. I question whether or not the fact that they had not been considered could be normatively justified. I concluded that it could not be. I also concluded that not all unlawful death that is gender-based amount to an arbitrary killing or an arbitrary deprivation of life, but I certainly suggest that the mandate itself and the arbitrary deprivation of life and arbitrary killings should be used to address the unlawful death that is gender-based. And by so doing, I believe we can raise the seriousness of those deaths and put it on par with killings committed by the state in more straightforward situations of arbitrary killings. So, thank you very much. So, any comments or questions or reactions? Are there other questions on that or on other aspect of my mandate?
Can we take a few questions and then she'll answer
Yeah.
questions together?
I'll tack on a question to that question. So going with the premise of that question, how do you expect states to fulfill their obligation as you see it based on this gender approach for cases where the violence is private, such as domestic violence, as you specifically mentioned?
Can Can you repeat?
Sorry, domestic violence.
Yes.
So domestic violence, because you specifically mentioned that as one of the areas of gender violence.
Yeah.
where things do do that.
Yes. Okay. Yeah.
How do you expect states to respond to rights of non-citizens, for example?
I can't hear you, sorry.
I was asking about the protection of non-citizens, for example, refugees, and how that might relate to your standards, given the organized protection of refugees.
Yeah. Okay. So is that linked to that? No. Okay. So let me respond to this, and then I'll turn to you. Yes, I agree. This is one. When I was doing the research for this report, I did find that the due diligence standard had expanded so much. It was almost difficult to see what was the essence of it. So that's what I tried to do in the report, not to add more layers of what it ought to include, because I think there is a great deal of technical details on the negligence standard. But I wanted to really go back to the essence of that standard, because I think sometimes we can lose track of it and see what it means in the cases of, for instance, of domestic violence. There are a couple of good practice which could be scaled up, and I think could have an impact at least on the prevention side of things. So one very basic thing is that in spite of all the awareness about domestic violence, we actually know very little on the triggers. I'm talking about not violence but killings, okay? Which is what I am concerned with. We know actually very little on the triggers, on the specific situations that may put women who are already victims of violence, but who put them at risk of being killed. And there are a couple of countries right now at local level of maybe private, mostly private initiatives, sometimes public initiatives that attempt to really go back to the data and or collect new data so that we can have a far better understanding of the specific elements that are going to put a woman's life directly at risk. At least in some countries where the data is available, that trigger is separation. So when women are about to separate from a violent partner, this is when they are particularly vulnerable to being killed. I think in the UK, it's 70% of the killings occur in that particular context on a localized basis. It's not nationwide. One of the recommendations I am making in my report is to really try to understand better, if you look at the standard, which is knew or should have known, the risk and the seriousness of the harm, to really try to understand each and every one of those, but particularly the risk, so that we can take preventive actions to tackle the moment where women in particular are at risk of getting killed, as opposed to a generalized regime of violence, which I looked at, but of course it's a bit outside my mandate. Did I answer? So I don't, I do not offer additional ideas on how that standard can be implemented, because there is plenty. The only one I'm saying is let's focus a great deal on prevention and on understanding that risk element of it, so that we can do something. The fact that states do not know about the risk does not necessarily mean that they fail in their due diligence. standard, because there are other aspects of due diligence. But I am suggesting that now is the time, now that we're starting to understand better the situation. I'm inviting states to really try to get a far better understanding of the risk and to ensure that institutions can respond to that risk from a violation of the right to life standpoint. The protection of non-citizens. Now, that is the object of my second report. I don't know if you know that. So the report I just presented to the General Assembly focused on the unlawful death of refugees and migrants. And on one aspect of it is to what extent are states responsible for protecting the right to life of refugees and migrants, including those that are engaged in risky occupations or indeed illegal occupations. So the standards there are fairly straightforward, and they don't they do not care whether or not the person is a citizen if the person is on the territory of that state. So the state has to take action to respond, to prevent, to investigate any kind of unlawful death and killings in particular committed on their territories, independently of the migration status of that person. It becomes more tricky when that person is outside the jurisdiction of the state, but may in fact not be under anyone's jurisdiction. So there are those border areas that are a little bit complex from that standpoint. There are people at sea, which also raise a number of questions from the standpoint of protection of the right to life and extraterritorial obligations. At least in the context of the sea, the international maritime law applies, and therefore we can make a very strong claim that people's life ought, that there is an obligation placed on states that are around that sea. They have an obligation to engage in search and rescue operations of migrants or refugees. But I don't know if I have answered your questions. The international refugee law also provides a very strong framework to protect refugees' right to life, including against forced return and repatriation.
Actually, directing my question to the National Community reports looking at gender sensitivity and
Sorry?
how you see the connection between the gender sensitivity approach to the issue of refugees.
Oh, I see. Very bad. I have to confess, very bad. I was hoping to have a far stronger gendered sensitive approach to the unlawful deaths of refugees and migrants. I found almost no data. My focus was very narrow. It was not focused on violence or torture, because then there is data, but on refugees and migrants dying in the context of their migration, and to what extent are those deaths amounting to unlawful and arbitrary killings, and which states are responsible for those deaths, and so on. The data on women dying is there is no data. There is no gender-based data there are very bad data on these unlawful deaths, and there is even worse data on the gender-based approach to them. What I did find, which is not yet empirically grounded, is that anecdotal evidence from people who are rescuing refugees or migrants, or from people who are collecting dead bodies, is that they seem to think that women are disproportionately represented among the dead as compared to the actual number of women migrating. So I remember very vividly Doctors Without Borders, who had the very unfortunate experience of coming into a boat where there were 22 dead bodies and 21 of them were women. You know, there was a couple of weeks ago a terrible video of a boat being found at sea with a large number of dead bodies. This is another one. Again, when you look at the video, well, I'm not inviting you to do so because it's quite awful. Large number of women. According to the refugees and migrants I have interviewed, there could be very good reason for that as to why women may be disproportionately represented, at least in the death at sea. They don't know how to swim as compared to men. So more men know how to swim than women for a variety of reasons. 2, they may be pregnant. 3, they may be caring for a child. 4, they may be located in a place in the boat which is meant to be protective, but in fact is a killer. So they are in the center of the boat, and if the boat capsizes, they have no chances. They are also more likely to die or to be very badly hurt by the gas, the petrol at the bottom of the boat. So for a number of reasons, at least at sea, there seem to be a number of reasons as to why they will be disproportionately represented among the dead, and some of those reasons may apply to other risky areas, for instance, crossing the desert. There again, anecdotal evidence from people I have spoken to who works on the Mexican-American border tend to show that women and girls may be disproportionately represented. But very hard to conclude with strong empirical data because the gender of the dead is usually not collected, at least not on a large-scale basis.
I'm afraid that's all we've